Today, we're going to take all that overwhelming, complicated criminal law jargon and translate it into a fun, clear, and highly structured mental map. So, let's just dive right in and give you the survival guide you need to conquer your syllabus.
So, here's a question for you to start things off. Is breaking the law always a crime? I want you to really think about that for a second. Well, spoiler alert, the answer is a resounding no. And understanding exactly why that is the very first step in your legal journey. We need to pivot right out of the gate and look at the absolutely crucial difference between two major areas of law that often get completely jumbled up during your first year.
Looking at the concepts here, first up we have criminal law. Its primary focus is deterrence and the punishment of the offender. Because the stakes are so incredibly high, we're talking about potentially taking away someone's physical liberty, the burden of proof is incredibly strict. It has to be proven beyond reasonable doubt. Now on the flip side, we have civil law. This isn't about throwing someone in a jail cell, it's about making a victim whole again. It's about compensation, it's about paying damages. And here, the burden is simply a balance of probabilities. Criminal law is what we're zeroing in on today, and as you'll see, the rules are incredibly strict.
Okay, here is our game plan for today. 1. The anatomy of a felony. 2. The 3 stages of execution. 3. The players. 4. Exceptions to the rule. And 5. Mala in se versus mala prohibida.
All right, Section 1, the anatomy of a felony.
So, before you can even start arguing about self-defense or who is an accomplice, you have to understand the most foundational concept of the whole system: what actually constitutes a crime under the law. That brings us to Act number 3815, widely known as the Revised Penal Code, which was enacted way back on December 8, 1930. Consider this your official rulebook. The core definition it gives us, right out of the gate in Article 3, states that acts and omissions punishable by law are felonies, or as they say in Spanish, delitos. It's not just about what you physically do, like a direct act. It's also about what you failed to do when you have a legal duty, which is called an omission. But to actually be a felony, it has to be committed in one of 2 very specific ways.
The first way is Dolo, which basically means deceit or deliberate intent. Article 3 says, there is deceit when the act is performed with deliberate intent. Let's put this in plain, everyday English. Imagine you're standing on a rooftop. You wait for your mortal enemy to walk by, and you deliberately drop a grand piano squarely on their head. Okay, that is Dolo. You had the freedom, the intelligence, and the absolute purposeful intent to achieve that harmful result.
But, what if you didn't mean to do it? Well, that brings us to culpa, which means fault or negligence. Article 3 tells us fault occurs when a wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Let's go back to our example. Imagine you're just moving that same piano, but you carelessly leave a slippery banana peel on the stairs. Someone slips, the piano falls, and someone gets hurt. You obviously didn't intend to hurt them, but your criminal negligence, your culpa, still makes you liable for the felony. So the absolute key takeaway here is that a crime needs an act or omission plus either dolo or culpa. But crimes don't just happen in a split second.
Moving right along, Section 2, the 3 stages of execution.
According to Article 6 of the Code, Step 1 is attempted. This is where the offender commences the felony directly by overt acts, but doesn't actually perform all the acts of execution because of some outside cause or an accident. Like, you try to shoot someone, but a bystander randomly grabs your arm. Step 2 is frustrated. You perform all the acts of execution. You pull the trigger, you hit the victim. But the victim miraculously survives because a world-class surgeon happened to be right there. The failure wasn't your choice, it was a cause totally independent of your will. And Step 3 is consummated. All the elements necessary for its execution and accomplishment are completely present. You actually succeed in the crime. Knowing these stages is super vital because the penalties literally decrease the lower down that ladder you go.
Next up, Section 3, the players, principals, accomplices, and accessories. All right, now that we know how a crime unfolds, who actually gets the blame? We are building out the roster of liability here, and trust me, liability isn't just for the main bad guy holding the weapon. We've got 3 main players. The principal is the star of the bad show. They take a direct part, they force others to do it, or their cooperation is so indispensable that the crime literally couldn't happen without them. Then you have the accomplice. They cooperate by previous or simultaneous acts, but they aren't strictly indispensable to the main event. Finally, the accessory. They come into the picture after the crime. They know it happened, and they help out by hiding the body, profiting from the stolen goods, or helping the principal escape. But here's a really fun exception for your exams. Under Article 20, you generally cannot be held criminally liable as an accessory if you are just helping your own spouse, parents, children, or siblings escape. Even the law recognizes the intense pull of family ties.
All right, Section 4, exceptions to the rule.
Speaking of exceptions, what about those really tricky situations where someone commits an act that looks exactly like a felony, but they don't go to jail? Well, the law recognizes that sometimes breaking the rule is actually the absolute right thing to do. We call these justifying circumstances under Article 11. We're talking self-defense, defense of relatives, defense of a stranger, avoiding a greater evil, and fulfillment of duty. In all of these cases, the law says you acted completely lawfully. Because the act was justified, there is absolutely no crime, and therefore no criminal and no civil liability. You are 100% in the clear.
Okay, but what if a crime absolutely did happen, but the person involved just can't be blamed? Enter exempting circumstances under Article 12. Things like insanity, being under 9 years of age, a mere accident without any fault, irresistible force, or uncontrollable fear. Here, unlike those justifying circumstances we just talked about, a crime definitely occurred. However, the person completely lacked the intelligence, freedom, or voluntariness required to actually be held criminally liable for it. So they might still have to pay civil damages, but they certainly aren't going to prison.
And finally, Section 5, Mala in se versus Mala prohibita. This brings us to the big finale. We are tackling one of the most classic, fundamental exam questions you are ever going to face. The absolute difference between crimes that are inherently evil and crimes that are just statutory wrongs. Let's break down these Latin terms into plain English so they actually make sense. First, mala in se. These are crimes that are inherently wrong, immoral, and naturally condemned by society. Think murder, rape, or robbery. Because they are so inherently evil, the prosecution absolutely must prove your criminal intent, your dolo. Good faith is actually a valid defense here. Then, on the other side, mala prohibita. These are acts that are only wrong because a special law or statute says they're wrong. Think carrying an illegal firearm or cutting down protected timber. Here, criminal intent is not required at all. You can't just say, oh, I didn't mean to break the law. Merely committing the prohibited act itself is enough to get you convicted.
But hold on a second. I'm about to give you a really critical nuance that is going to score you major points on your exams. Check out this recent 2023 Supreme Court ruling, the Valenzuela case. The Supreme Court clarified that yes, for mala prohibita crimes, the prosecution doesn't have to prove you had an evil criminal intent to break the law. However, they absolutely still must prove volition. They have to prove that you freely and consciously committed the prohibited act itself. If you didn't act voluntarily, you cannot be convicted, even under special penal laws. It's a huge vital protection against unjust convictions for totally accidental violations. So, are you ready to survive the rest of your criminal law syllabus? Honestly, you totally should be. What we've built together today is the foundational scaffolding. You now understand the anatomy of a crime, how it progresses step by step, exactly who is liable, the defenses you can legitimately use, and the major difference between inherent and statutory wrongs. This mental map is quite literally the key to unlocking the rest of your dense legal textbooks. Keep this explainer handy, apply these core concepts to your future cases, and you won't just survive your exams, you are going to crush them. Thanks so much for learning with me today.